Excuse me, folks. We're about to start. Thank you.
Everybody, can I get your attention again? Thank you.
Okay, before we start,
I just wanted to make one plug, since there's lots of Northeastern students here, that I'm doing the 32BJ Fellowship right now, and they are accepting applications for January. I would love for more Northeastern people to have a fellowship, so if you are a 3L, please apply and feel free to contact me. And anyway, thanks.
thank you. Okay, so this topic, new topic, the Google dilemma, and boy has the environment changed a lot in the last few weeks. So it is more timely than we ever could have imagined. We have Rahsaan Hall from the ACLU, Elizabeth Houlding from PPD Arnold, and Paige Walker-McKissick from Siegel-Reitman. Again, their information is in your book. There's a lot of really interesting things to talk about, so I won't go on anymore. We're going to start with Rahsaan on the interesting perspective of an organization that represents both sides of a lot of these issues.
All right, thank you. Good evening, everyone. I guess I feel like I have to start off with a bit of a disclaimer. The beauty and value of being a member of a multi-issue organization is that you don't have to deal with all of the issues. And so I will shy away from the temptation to play the role of jack of all trades and master of none, because I'm not a First Amendment practitioner. The work that I do is racial justice work, and so I still feel that that's a relevant perspective to bring to this conversation. But I want to put that out at the outset. So the question that you tried to lob to me from the last panel, I'm going to avoid that altogether. And so I want to talk a little bit about an experience that we're dealing with at the ACLU as a bit of an anecdote. And you know, in the aftermath of what happened in Charlottesville, where neo-Nazis and white supremacists marched on the square, the ACLU came under fire because, specifically the ACLU affiliate in Virginia, came under fire because of its role in advocating or litigating for the organizers of that particular march to have a permit. And in the fallout after that, a lot of critique was leveled against the ACLU, especially because of our increased efforts at doing racial justice work. How can we, as an organization, on one hand, litigate and advocate for free speech, including hateful speech, or offensive speech rather, under this notion that the way to combat offensive speech is with more speech, while at the same time doing racial justice work, advocating for historically disenfranchised and marginalized communities. And as a result of that external critique and criticism that we were experiencing, there were some internal conversations, and I'm not telling any secrets or exposing dirty laundry that's not publicly available or widely known. But because the ACLU has increased in its staff capacity and increased the diversity within the organization, there was a lot of internal struggle around our organizational identity. And so there's the tension within the organization. Can we continue to be this First Amendment purist organization, or do we want to be more comprehensive and have a broader approach to social justice and civil liberties issues? And it has been a very dynamic conversation within the organization, and it's forcing us and challenging us to grapple with these issues, especially when we talk about having a commitment to diversity and wanting the organization to be more reflective of the society and the people that we say we represent and advocate for. So I think that's something to consider when we think about the Google dilemma on one level. And I guess another disclaimer I should put out is, even though I am an ACLU employee, some of the things that I say here tonight, well, let's just say most of the things I say here tonight are not the views of the ACLU. They may be informed by them, but these are largely, this is Rahsaan Hall, black man in America, Northeastern grad, 1998, with a particular view and perspective on certain things. And so in this particular case of James Damore, it's not necessarily a dilemma. And I say that because, you know, the statement that he made within his organization wasn't protected speech. It wasn't protected speech, one, because he was not disciplined for it by the government. And also because he made those statements within the context of his work, using the resources of his employer. And so at a certain level, again, it's really not a dilemma. And so the title of this panel, this conversation, balancing diversity, protected speech, and what do we got? And a workplace free from hostility. I pose a question: how do we do that balancing? And not in not from a legal analysis perspective, but which side do you put which issue on to weight against the other? Do we put diversity and a workplace free from hostility opposite protected speech? And if that's how we're doing it, which I don't think that is the appropriate way to try to tackle this issue, but if that's the way that we're doing it, one side is always going to lose. And usually, more times often than not, and there's probably a lot of debate around this, the side that ends up losing is the side of diversity and a workplace free from hostility. And folks will say, well, wait a minute, there are protections in place. People get fired, like this individual got fired, but I guess it's for me, it's more than a legal question. It's a question around values and principles for organizations. What is the type of environment that we want to create? And how is our workplace a microcosm of the larger society? What are we bringing in from the outside world that influences, that either perpetuates, maintains, or shifts the existing standards? And so, Mark mentioned that this is a very timely conversation because we are seeing the overwhelming level of resistance and truth-telling about sexual harassment and sexual misconduct. And it's a beautiful thing. And I'm loving it. And as much as I hate to see people who are in positions of power and people who I believe to be progressive being called out on this stuff and being disappointed by it, I'm glad. I'm glad because the conversation is beginning to change. And so I guess the other side of that coin, when we talk about this kind of balancing, when you put these two values against protected speech, there's an argument that could be made that says, well, it's the diversity in the workplace and the workplace free of hostility that always wins. And if that is the viewpoint or the perspective that people come to this issue with, there's a question around what's really at issue. And for me and some of the work and advocacy that I do, the deeper question is this really about white, cisgendered, heterosexual males not being able to say and do the things that they have historically and traditionally done? And what we've been seeing in the media now, more so than ever, and again, not exclusively that group, but that group as the norm, is pushing back against that and saying it cannot continue to exist that way. That standard can no longer exist. And so, the premise that James Damore shared in his Google manifesto that he asked folks to agree with him on is once we acknowledge that not all differences are socially constructed or due to discrimination, we open our eyes to a more accurate view of the human condition, which is necessary if we actually want to solve problems. Therefore, there are less women in positions of power because of genetics, because of who women are. Therefore, there are fewer people of color in positions of power because of, I don't know, lack of intelligence, right, or lack of abilities. It has nothing to do with societal discrimination. And a statement like that is problematic because it doubles down on ideologies of suppression, of oppression and supremacy, and it contributes to an environment in a workplace that is hostile, that is uncomfortable. How can somebody who propagates those points of views as it relates to, in the context of a statement about women and the lack of diversity and leadership by women, then be given the charge of working with women? How can a person like that who has a view similar to that around issues of diversity then be given the responsibility of working with a group of diverse individuals or representing the organization in communities that are diverse? And as the demographics of this nation continue to shift, it becomes more and more problematic. And so when organizations begin to seriously value diversity, bringing in more people of color, bringing in more women, bringing in people who are gay or transgendered, bringing in people with different language abilities, there's going to be, this tension is going to be ever present. And organizations, entities, employers need to really wrestle with what are we placing value on, particularly where it is speech that is offensive and not protected. I think there may be a different conversation for government employees who are making statements on their own time about matters of public concern, but when it has to do with things that are happening in the workplace that impact the spirit, the energy of the community of the workplace, it is highly problematic. And from a perspective of values, I think there needs to be an investment of ensuring that the workplace is something that is a place that is positive, that is affirming, and that is free of hostility. So, that's far from a legal analysis of the issues, but I do think that is a perspective to have. And I think it's also important to recognize the importance of taking into account the voices of the marginalized and the oppressed. When people say, why can't I say those things? Or, oh, it was just a joke. Who is the person that is saying that? And what is their position vis-a-vis those who are the ones who are complaining of the hostility that exists? So I'll stop there.
Okay, great. Thank you. Elizabeth, okay, you're representing Google. They just made a phone call, and they said, guess what happened?
So, I'm in the unique position of the employer having gotten it right here, in my opinion. And Rahsaan has already said a number of things that I would have said if I were representing the employer in this situation. I do encourage you to read the document that this employee had submitted. And I don't know if you have, can you just let me know who has read it? So I do encourage you to read it, because obviously if you're if you're a lawyer getting a call, whether it's me or Paige, regardless of which side you're on in employment-related disputes, you're going to get the call, you're going to have to read it, and you're going to have to figure out what to do. This is it's a very long piece that was submitted internally. And I think it's important to understand that it was internally submitted within the walls of Google on an employee-related forum. There are, dozens and hundreds of them, and people can subscribe to them or not. And one of the things that this employee who wrote the manifesto or this think piece or however he would have described it, I mean, I should tell you that the title of it was Google's ideological echo chamber. That's the title of the piece that he wrote, and that initially apparently was not super controversial within the wall. I'm sure it was controversial for certain people who read it, but it did not blow up until it sort of became known outside of the company. I think that when the CEO of the company is getting on a plane to fly home from his vacation because of this thing you have written and submitted that you think was just supposed to be thought-provoking, apparently, you're going to lose your job. So, that's probably the easy decision, but I don't want to be flip about it, because I think that there are, there were certainly things that had to be weighed. They have to be weighed. What did he write? How did he express it? Where was it published? Why does this exist? And it's overly long as far as I'm concerned. I can see that there are pieces of ideas that he wanted to express there and circulate and say, we can do better at diversity. Fine. I think that's probably not controversial, and people can talk about how we can do better at that. But there are also pieces that are just profoundly offensive to whoever it is that you think is going to be reading this. I think that when you describe women as more neurotic than men, and you don't think that that's going to cause a problem, there are other ways in which the piece sort of points towards a biological determinism. And whether this is about women or whether it's about other employees or other people in protected categories, it's going to be problematic. So, as far as this, one of the things that I find interesting is that people are often wrong about their free speech rights, and Rahsaan would know far more about this than I do, but. You have the right to use the workplace computer, obviously, which you did, to communicate within the walls of Google in this forum. You don't have the right to be free from the consequences of your speech. You do not. And I think that is a very powerful thing for employees within a private employer setting to know and understand. It's not all free. You don't just get to say it and then not live with whatever those consequences are. And the employer, in this case, got to make a decision about what to do. It became obviously much larger than this document, right? You have thousands of employees, some of whom may say to you, you know what, and Rahsaan already raised this, how do you then put this person in a position, if he's to rise in the organization, of supervising people? How do you do that? And don't people have a right to say, I just don't want to be supervised by someone who might think that about me, whether I'm a woman or whether I'm a woman of color or whether I'm in any number of protected categories. So I think that the employer has to run through its options, but that once the storm hit, the dilemma is for the management side lawyer and for the employer and for whichever decision makers are involved in the decision at the place of employment, what are our choices here and how do we move forward? And it's not only a legal decision, it's a values decision. As Rahsaan said, it's who are we? Who are we as a company? We've made all of these efforts and to work on diversity. The diversity numbers in the tech industry are still not good after tons and tons of initiatives. And what do we want to do about this? So in my opinion, they made the decision that they would rather take a stand and say, we believe that you violated our code of conduct, and that certain aspects of what you published internally did not conform with our code of conduct. Because the code of conduct, I haven't seen the entire thing, but says Googlers are expected to do their utmost to create a workplace culture that is free of harassment, intimidation, bias, and unlawful discrimination. So the employer gets to make that decision about whether or not they think that this was a violation of the code of conduct. And the employee obviously disagrees and says, no, I did not, you're wrong. And I'll hold off on comments about the claim that he then filed through the NLRB related to whether this was protected speech in some way through through speech related to the conditions of his employment. I think that's a stretch, but it's not, that's not really for me to say how that will ultimately go. But I think that on the side of the employer, they've made their decision about which battle they're going to fight related to this employee. And if they fight the battle against him in the setting of the NLRB and they lose, then I still don't think it's a loss for them, because they're an enormously important employer, and they made the decision about what they're going, what is it they're going to ask their employees to do. And it's not impossible that they would have been facing hostile work environment claims by colleagues of this man, or by people who felt profoundly affected by this this manifesto that he wrote. And there are also lots of other questions that can be raised about it, but I expect there'll be lots of conversation about it, so I'll stop and Paige can talk, and then we can all talk together.
Okay, so I tasked Paige with the unenviable task of being the lawyer when James calls up and says, hey, they fired me. But then also I gave her the other task of what happens when the group of women call up and say, we want to file a hostile work environment claim. So,
take it away. I'm in the unusual position of having to try to come up with a defense for an employee who made comments that are completely unacceptable. Just to sort of put some meat
has
on
that ever happened before in your friends?
just put a little meat on the bones of the facts. For those of you who didn't read his manifesto, he wrote it on a flight to China, and it does come across as like a little bit of stream of consciousness. And he emailed it to the organizers of Google's diversity team meetings. And when that didn't provoke a response, he sent it to these internal employee listservs, like a electronic discussion forum, essentially. And basically his argument boils down to his belief that the psychological gender differences explain why 80% of Google's engineers are men, and most of its leaders are also men. So his points are that women are more agreeable, less assertive, more interested in people than things, more concerned about feelings, and for all of those reasons, they've been unable to excel. On the other hand, men care less about work-life balance, they're more motivated by status and more interested in things, so they've excelled in their careers. The purported purpose of writing this manifesto was to inform Google as to how it could better help women move up the ladder at Google, that it was these affirmative action policies that it had were just not going to cut it. It was essentially, in a way, he was making a reverse discrimination claim. So that's a little bit more on background. And I'm going to do something a little bit different than what Mark explained, which is that because I'm mostly a labor lawyer, I'm going to do a little bit of employment. But I was thinking of it more in terms of, not what if James Damore walked into my office, but what if the union walked into my office, if Google was unionized. stretch. I mean, there's been a little bit of momentum in that direction. Actually, interestingly, after Trump was elected, the tech industry kind of got animated about the prospects of unionizing, and that was also in conjunction with the recent unionization of third-party contractors that Google and Facebook use, like the shuttle bus drivers and things like that. So we'll just imagine that Google is unionized, and that James Damore was a member of a union when he wrote and distributed this message. And so, union president comes into my office and says, what do we do with this guy? He's been fired. We have to file a grievance. How do we proceed? So, as a union lawyer, you have to think about things a little bit differently. You're not representing an individual. You're representing an organization, and that organization has a duty of fair representation to its members. So the union decision-making process is going to be a little bit more layered and a little bit more complicated. It's not just, does this case have merit, but is this case worth pursuing on all of the members using membership dues that funds our organization? That being said, unions have pretty broad discretion in deciding whether or not to take cases. The duty of fair representation, as many of you may know, basically says you can act in a manner so long as it's not arbitrary, discriminatory, or in bad faith. So the Damore case kind of, for me, is reminiscent of other union, or pretty common situations where you have members pitted against each other. So you have a sexual harasser an accused sexual harasser who's been disciplined or fired, and then you have the victim. Or you have an altercation in the workplace where you have two employees who have different versions of what happened, and they're both looking for you to represent them. So here in Damore's case, as a union, you have to comply with your DFR obligations. And in considering that, thinking of the membership as a whole. The member, in this case, there was total outrage at what Damore did, and that was completely appropriate. So if the union takes the case to arbitration under the collective bargaining agreement, you can wind up with the membership, disowning the union, being very upset about what the union is doing. And you can also be put in a situation where you're in an arbitration and members are testifying on behalf of the company, which you never want. So those are just sort of things that I was thinking about as from like a labor lawyer's perspective, representing a union. Another thing that's sort of interesting to think about is in considering whether it would have been in the union's best interest to arbitrate Damore's case had he been unionized, is that unions are in these days in particular cast as political machines. We're just taking in money and it's all about politics. And one way that unions sort of prove themselves is by representing the unpopular. So what Moore did and said was totally outrageous, but did he deserve to lose his job? If the tables were turned and it was someone who said something that we completely agreed with, but you had a CEO who was very conservative, you have to sort of think on both sides. And also, was there some lesser penalty that would have been appropriate? So here's how I would advise the union. I mean, there's a lot of different things going on here. You have his termination, which could be, you could arbitrate under the collective bargaining agreement. Was there just cause? You have the ULP, which he ended up filing on his own. If he had had a union, perhaps the union would have filed it. And then you have just the discrimination issues. I would advise the union to treat the case like any other. You have to do a careful investigation, file a grievance, follow the steps of the CBA, investigate, review the code of conduct. Was the code of conduct collectively bargained? Is it lawful under the NLRA? And then look at how the code of conduct has been applied to other employees and how discipline was meted out to those employees by application. meet with Damore, make sure a union rep is present, avoid any creation of an attorney-client relationship with Damore, and make clear you represent the union in determining whether or not there was a violation of the CBA. Evaluate the merits of the case, and then present it to decide whether or not to take it forward. At the end of the day, the union could very well decide, this is not the kind of conduct we want to protect. We don't agree with the speech. This is not what our membership as a whole agrees with. But as a lawyer advising the union, you would have to go through all of those steps. Make sure that the union is complying with its duties under the DFR. In terms of the NLRB charge, which Damore did file on his own, it's a common misconception that the NLRA only protects unions and that you have to be unionized to file a charge. Anyone can file a charge, and in this case, Damore did. And so as was mentioned on the prior panel, you have a Section 7 right as an employee to engage in concerted protected activity for mutual aid and protection. And it's a violation of the Act for an employer to interfere with that right. So essentially, Damore is saying, Google fired me for raising these workplace diversity issues with my coworkers and making friendly suggestions about how we could do better. So in just the legal analysis of the merits of whether he'll prevail on that claim, I tend to agree with Elizabeth, which you just mentioned briefly. It's a tough one, particularly because you have to show that his action in sending out this manifesto was concerted. And by that, I mean it was done on behalf of other employees or in an effort to induce action by a group of employees. In his case, it was directed at management. It's not like other coworkers signed on. He wasn't asking for anyone to support it or join in. It was sort of a unilateral action. So I think he's going to have a tough time on that factor, although there have been some recent cases that have pushed the outer bounds of that. There's a case called Fresh and Easy Neighborhood, which involved like a supervisor who drew a sexually explicit graphic that related to an employee. She made a copy of it and asked people to sign as witnesses, and told her fellow employees that she intended to file a complaint. And that was found to be concerted, even though they didn't join her in that complaint. They were merely signing this piece of paper as witnesses. But the board said that was enough for it to be concerted. And there is one line in his manifesto that says, and I don't know if this was added after the fact, but it says something like he's gotten a lot of messages from other Googlers since he posted this, thanking him for standing up for, these ideas that they were too scared to present in the past. So maybe, but I don't know. Posting to the internal discussion board is helpful because it showed, the forum of where the discussion took place, kind of suggests that he was looking for other people to join in his view and his calls for action. But it is a tough call. There is a line of cases about under board law about losing protection of the act, like if you if your conduct is disloyal or disparaging to your employer's services or products. I don't really see those applying there, but I guess Google could have an argument that this kind of speech is damaging to the kind of service it's trying to provide for its users. One other point that I'll make on that is that the ULP and any potential discrimination complaint, in light of the last panel, I mean, with the new Trump era and the appointees to the NLRB, and particularly under an administration where the DOJ is saying it's going to start, it wants to go after affirmative action policies like at Harvard and such for reverse discrimination. He might find more reception in the Trump era agencies to these types of claims. Not a claim that I would take as an individual employment lawyer, but there might be he might have more receptivity now.
Was he a supervisor?
He was a senior engineer, so he had quickly worked his way up. I think he was only there for like 3 or 5 years, and he had been moving up the ladder pretty quickly. But I don't know if he directly had any supervisees.
Okay, I remember just reading some comment on some listserv about he was a supervisor and hence not covered by the NLRA.
Yeah, I mean, if in fact he had any assigning people, hiring people, participating in those decisions, then absolutely he wouldn't be protected, at least for purposes of
Do you think that cases, I mean, certainly a lot of cases of pretty offensive speech that gets protected, and my recollection of the manifesto was that it wasn't coarse.
No.
You didn't like, some of the stuff he raised, but I think there may well be arguments that this was, commenting on trying to improve the workplace or change the workplace, and it'll be interesting to see what they do. Carl?
I assume this took place in California. California is one of the few states that has a statute that effectively grants First Amendment rights to private sector employees. How might that affect this?
What I've seen on it is that it protects. It's intended to protect political activity by employees outside of the workplace, but that the argument, and I'm not practicing in California, but that the argument will be this is not the kind of political activity that the statute is intended to protect, that it's simply workplace speech about some suggestions about how to improve working conditions for everyone, and that they don't really think that he's got much protection under that statute.
Well, what if it were in Connecticut, which has a statute that is very explicit that private sector employees can proceed against their employer on speech claims as though the employer was the state actor. As though the First, I'm not saying it was, as though the First Amendment was applied.
I just have I don't know about the Connecticut or California statutes specifically, but I do know that in public sector cases where there's a free speech right, that it's limited. It's not unlimited, and that even if it's protected speech, if it's disruptive enough to the workplace, that can still be grounds for termination. I remember reading about cases, termination or maybe a lesser penalty. But I remember reading at least one case about a police officer who said something that was so I forget what it was that he said, but whatever he said, the police department came to the conclusion that nobody would feel safe contacting the police. It was so disruptive to their mission. So in this case, I would think there could be an argument that it was so disruptive to the workplace that had to get them out of there, even if it was protected. But.
Joe?
Well, even under Connick versus Myers, although that's sort of been watered down by that Garcetti case subsequent to that, but is it a matter of public concern that the person's talking about, or is it a matter of internal workplace actions? And I think my sense is that you could argue both sides of this. I think it's a stronger Section 7 case than I think some of the panel members. I think, especially the Trump board, if we're going to call it the Trump board, although, the 3 members of these, are relatively middle of the road type of Republican appointees, and the new one who we just announced today, that came out today, is another sort of relatively middle of the road person. That being said, this might be attractive to them. It's a Section 7 case. You're talking about, you're trying to get other people interested in workplace environments, take a broad view of what's of interest to your coworkers. I think the concerted part is easier to get over than you might think, at least if you apply a lot of board law in more recent vintage, where the concerted piece of concerted protected activity has been a lower hurdle of recent years, I think. I have a question for the panel, though, if I can, Mark. I love the idea of the employers get to have a culture that they want to encourage in their workplace. And if we work for Google, we might embrace that culture and say it's a diverse culture, it's a culture that embraces. But what if you work for Hobby Lobby? You know, and that's a different kind of workplace culture. And where do you come down if the workplace culture that they want to enforce is one that is maybe an anathema to other types of rights, such as my right to get birth control paid for through the Affordable Care Act, and others, because the Supreme Court says that a corporation now has religious views according to Hobby Lobby. So it's like, okay, I guess so. I disagree with that, but that's the way of the world. So I'm a little concerned, and I represent employers that want to enforce their culture, whatever crazy culture they have, they want to enforce it. But I am concerned about that, right? You know, the idea that if my boss is a nice guy, or if my corporate enterprise, I agree with its ideas, that's one thing. But if you're working for Hobby Lobby and you're, you know, a Democrat in Alabama, maybe you're not feeling so embracing of the idea that your employer gets to enforce its cultural concepts on you. So I think it's not as easily sort of sorted when you might disagree with what the corporation wants to enforce as its corporate culture. And I was wondering if other folks had thoughts on that.
But the reality, the reality of the legal structure is that the corporation does get to do that. And unless you're impeding on protected categories or creating a hostile work environment or impairing protected concerted activity, you do get to do that. And you know, I think Hobby Lobby, unfortunately, you know, from a moral perspective, can in fact say, you know, we want to promote this cultural, conservative culture. They can do that, but I think that the answer to that concern is more unions, is more, you know, industrial democracy. But you know, the legal scheme that we have allows you. If a client comes into me and says, you know, my employer fired me because I didn't like the fact that they weren't paying for birth control, maybe there's some kind of a gender thing there, but probably not. And I probably wouldn't take the client's money to take it. I would say, unfortunately, you work in a fascist dictatorship. And, you don't have free speech rights. And if you want to have, you know, protections, the next time somebody talks to you about creating a union, you're nice to them.
So I think this is a little bit more complicated case in my view because of what I agree with what Joe said, because I happen to know somebody who works at Google, and I think he's a classic Google type employee, and he's a PhD with postgraduate honors and everything, and everybody there is quite brilliant, but the ones I've met who work there are all living in their own little world. And the corporate culture in Google is exactly people like this, who might be a little bit off and say inappropriate things, but be quite successful and competent at what they do, and in fact, quite brilliant at what they do. So there might be an argument that the board is struggling with. We don't know what's happened to the case, I guess. It's taking a while for it to be processed. If it hasn't been dismissed at this point, something is going on, right? That the prevailing culture is much as tolerating people like this, and I suspect that there are other examples of, I'm just guessing, we don't know obviously, of other people communicating on that bulletin board, that email bulletin board or whatever it might be, saying lots of inappropriate things that echo this.
Yeah, it raises an interesting question, because from a neutral perspective, you get cases coming to you, I think about it in discipline cases, and the police, and it comes to you and you know, this person has done a terrible thing, and the union argues, yeah, of course, but that was here on the terrible scale. Let us tell you about all the terrible things here where the people got a suspension. And, you know, from a neutral's perspective is we have to write the decision so you can't have disparate treatment. And then the SJC, you know, gets on their high horse and says, how could you possibly decide this? And I'm wondering, you know, when they start looking at what the employer does and where you draw the line, is, okay, let's start examining, let's do a dump of all that listserv and see what's probably a lot of egregious things, but those are some really bright people. You know, they made us a lot of money, and we didn't take any action against them. And you know, is that then going to?
Yeah, it's no different than any discrimination case. I mean, that's what we do with every case. Is you say, okay, the company has a rule, you know, that if you are driving in a company vehicle and you get in an accident and it's found to be your fault, you can be terminated. Okay, fine. And, you know, Jose gets in an accident, he's found to be at fault, and he's terminated. Okay, but John, Sean, and, you know, William got in accidents that were found to be their fault and they weren't. So, I mean, I don't see this. I think the considered effort piece, knowing very little about NLRA law, but the cases that I've read on considered effort, I think that piece of this is probably more problematic. But yeah, I mean, if you do a dump of what, you know, you get some odd techie types with how they, you know.
Or within the range of normal techie types.
Right, you know, there's going to be some weird stuff out there. And what does it mean that this got picked up by, you know, viral social media and he, you know, they might find some really weird stuff and he might be okay.
Other questions? Any concluding comments you folks want to make? Yes,
Question.
please, Jim.
What does the panel think of what would it take for something like this to rise to the level of creating a hostile work environment, in your view?
I mean, so the standard at least under Massachusetts law is severe, pervasive, offensive conduct. You know, I think it would be tough in this case. You have one instance, it was offensive, the company acted swiftly and did what they did to, you know, in its view, in its protection of the people who were rightly offended. I don't know if maybe it's severe enough to meet that standard, but I don't think so because the company came on board so quickly. If the company had sat back and not done anything, and then people had come and complained and said, look, we're really offended by this guy's conduct. If he was a supervisor, like was mentioned before, and people felt uncomfortable working with him, you know, in light of the views that he espoused, I mean, maybe, but I think with the facts that are there, it would be a tough argument to make.
One of the things I was thinking about kind of in that context, and it came up here too, is were there other forms of discipline or sanctions that could have been meted out to him? But once it went beyond the walls of Google as well, I mean, it's giant, right? It's huge. And if you don't exit him from the workplace and you say, well, you know, we encourage everyone to exchange their ideas. He was just, you know, playing along with everything we've encouraged people to do, including people who may have unpopular opinions or forms of approaching these issues. But once it is this giant issue, can you really say, you know what? We brought him in, we gave him a written warning, we're good now. I mean, who's good now, right? I mean, no one. He's not, because he feels that this has had precisely the effect that he thought it would have within Google, because it's a so-called echo chamber. And a whole lot of other people aren't okay now either. So, I mean, I think that it would not have, if they had kept him, it would not have been hard. And you're plaintiff side and I'm not. It would not have been hard for people to go to your office and say, this is not okay with me. That they have tolerated this and they have said that, oh, it's just a free exchange of ideas. And, you know, we'll all just, you know, happily talk about how we can do better at diversity.
I mean, I think also the context matters, right? If it's Google and also on your staff are, you know, Charlie Rose, Al Franken, and we'll throw in Louis C.K. for good measure, you know, is that, you know, severe and pervasive? Probably yes. But I also think there is the legal standard of what is a hostile work environment, but there's also this more amorphous question around, again, values and culture, and what happens when he gets the lesser punishment. What is the message that is sent, and what is the harm that is done to the people who, again, are oftentimes the most marginalized people. And I know that's difficult for a room full of lawyers, because it's like, I care about these things, but my job is, what is the legal standard?
Jessica.
I really wonder what's going to happen nowadays where events or gropings or statements really, no physical touching, that really wouldn't constitute either quid pro quo or hostile work environment, sexual harassment. But because they've blown up on social media and blown up on the internet and they're front and center, it's really going to be interesting that the company felt they had really no choice but to fire the perpetrator of the, let's call it misconduct. It wouldn't rise to the level of sexual harassment, in a case leading to damages. And I wonder if there's going to be some sort of change in the law, sort of defense that, look, we just couldn't possibly, and because I interpreted your question a little differently when you asked about hostile work environment. I thought, how would it constitute hostile work environment for the group of plaintiffs that might come into plaintiff's office if it's one manifesto, and otherwise this guy was a great guy, but very woke. I mean, he doesn't sound very woke, but so that I just think it's I just wonder whether there's going to be a body of case law about what the employer had to do, even if something didn't constitute workplace harassment, because of its global publicity.
I had that same conversation with a reporter today who was dealing with the sexual harassment stuff. And she said, "Did you see the latest one?" And I said, "I don't know which one you're talking about." She said the Senate president's husband. And I Googled it and I said, "Oh, great." But two things we talked about. One was, in this case, I think a hostile work environment claim, in my perspective, if I got a call from a woman or a group of women, I think that you've got the severe or pervasive only if the company does the slap on the wrist and it's perceived as, countenance of this view, and that either, employees rightfully or wrongfully perceive their supervisors to have adopted this new view or company culture. And in that instance, I think maybe perhaps you could bring a hostile work environment claim. But I also wonder, in light of the kind of explosion in the media of these claims, if companies aren't going to have the opposite reaction and try and toughen up and have a more aggressive defense to this, because these things are everywhere. And if they're going to let go of everyone in their employ who has sexually harassed someone, they're going to let go of a lot of people. And so what do they do, assuming that this kind of behavior is much more prevalent than we have chosen to believe or have understood? Perhaps we're actually going to have case law to, the opposite effect, where it's going to be more difficult to resolve these claims early on because of, slippery slope flood of litigation.
Or they can hire more women.
Yeah. Seems appropriate place to stop. Thank you very much. Thank you very much. It was great.
Yeah. So right.